Thank you, Leslie. Hello, everyone. I am John Guse. I'm one of the supervisors here out at the Veteran Benefit Administration in Phoenix, not the hospital, but the regional office. And today what I'm going to talk to you about are presumptive conditions, some of the old ones, some of the new ones, ones that have been going on for years, and ones that are just coming to fruition right now. So without further ado, let's go to the next slide, Leslie. I'm going to be talking about four different things, what presumptive conditions are, some categories of presumptive conditions, obviously not an entirely inclusive list of categories, the eligibility for certain presumptive conditions, and then we'll open it up for any kind of questions, and then I'll turn it over to Mike. All right, next slide. These are the references that we use. 38 CFR, the Code of Federal Regulation, is kind of our Bible as far as the presumptives are concerned and how we assess it, how someone would be able to qualify for a presumptive condition. And then M21-1 talks about the special considerations for claims based on herbicide exposure in Thailand during Vietnam. So there are a variety of different references. I tried to just simple it down to just a few of them that you might want to look up a little bit later on. Let's go to the next slide. So what is a presumptive condition? It's certain disabilities that were caused in military service because the veteran was at a particular location or was exposed to different circumstances. And I'll get into some specifics about that. The last line there, I think, is probably spells it all. If a presumed condition is diagnosed in a veteran within a certain group, they can be awarded disability compensation. Next slide. So I'm going to look, or we're going to look at 5 different presumptive categories. The first 3, a former prisoner of war, radiation exposure, and Camp Lejeune, have been in place for many, many years. However, the veterans who were exposed to herbicide during the war in Vietnam and the Gulf War veterans have new presumptive conditions that are coming to light. So we'll delve into that a little bit more too. Next slide. So a former prisoner of war, these are conditions or medical diagnoses that a veteran who was a prisoner of war can be compensated for. You see psychosis, you see organic residual of frostbite. That often happens with individuals who were in Korea, prisoners of war during that time, stroke and its complications. And as you can see there at the bottom, on or after October 10th, 2008, osteoporosis, if the secretary determines that the veteran has post-traumatic stress disorder. So the again, it's an evolving method of determining whether or not a veteran or if an individual winds up getting some type of diagnosis of a medical condition, and we're able to tie it to where that individual was at a particular point in time. Next slide. Radiation exposure. Now, this occurred not only during towards the end of World War II, but then it also took place, radiation exposure took place during the years that following World War II and all the way through the Korean War, where testing was being done in certain locations. A lot of them were in the South Pacific at some remote island areas. And for lack of a better explanation, it wasn't very well understood at that time about things like wind drift or fallout. And so as a result, there were veterans that were in harm's way. And the result of that is that they may have developed some type of cancer, leukemias, just a wide variety of different cancers that you can see there, carcinomas, multiple myeloma. It's quite an extensive list for veterans who were exposed to radiation at some point in their career. Next slide. Camp Lejeune presumptive. So this is the list of disabilities that veterans can be compensated for if they were in Camp Lejeune. The next slide is going to show you what years that was, what years they are considering, and what the circumstances were considering there. But what you see there also are many cancers, lymphomas, leukemias, myeloma, Parkinson's disease. So there's quite a bit in there that is related to the incident that happened at Camp Lejeune over many, many years. And if we go to the next slide, we'll see what those years are and what had happened. So for the purpose of this section, contaminants in the water supply means the volatile organic compound. I'm not even going to try that word. I'm not going to try the next word, benzenes and vinyl chlorides that were in the on-base water supply system located at the United States Marine Corps base Camp Lejeune during the period beginning on August 1st, 1953 and ending on December 31st, 1987. So they were able to determine many years ago that the water supply at Camp Lejeune had been contaminated, and the result of that are that if we can show that a veteran was stationed at Camp Lejeune during that period of time and they have developed one of those types of cancers or myelomas, leukemias, Parkinson's, things along those lines, that they can make application for the benefits, and we'll work our best to try and get them those benefits. Our next slide. So this is where the VA does a great deal of work, and it relates to herbicide exposure. Many of us probably have heard the term Agent Orange. This is what it's referring to specifically. Herbicide exposure is exposure to the chemicals that were used in Vietnam and in Korea and in Thailand at certain periods of time during the period of 1963 to 1975 when Vietnam was going on, and specific years regarding the Korean War, or at Korea at the demilitarized zone. Let's put it that way. What you see here are, and this is several slides of presumptive conditions. You see the chloralacnes, you see the Hodgkin's, ischemic heart disease was added a few years ago. B-cell leukemias was added a few years ago. Type 2 diabetes has been on there for several years now. If we go to the next slide, we can see a few more. The multiple myelomas, the prostate cancer, the early onset of peripheral neuropathy, respiratory cancers, soft tissue sarcomas, Parkinson's disease was just added recently. So many, many more. There's, I believe, another slide on this. Next one, please, that also gives you more presumptive conditions. These are the brand new presumptive conditions that have been added for herbicide exposure. So bladder cancer, yes, hypothyroidism, which is the underactive thyroid, and then Parkinsonism or Parkinson-like symptoms. So if we think about Parkinson's, oftentimes we might see an individual that shows the shaking hand, that almost like a tremor of some type, although they may not have been diagnosed with Parkinson's at that time. Well, that is a Parkinson-like symptom. And part of the reason I bring this up is because many times an individual might be misdiagnosed with something other than Parkinson's when in fact it is Parkinson's. So it's adding that on there opens up a much bigger window for veterans to be compensated for things that do look like Parkinson's, but have not been officially diagnosed as Parkinson's. Next slide. So the years, I made a mistake there. I said 1963. It's actually January 9th, 1962 to May 7th, 1975. That's the period of time that they consider the Vietnam War was taking place. And it includes a veteran who, during active military, naval, or air service, served in the Republic of Vietnam during this period, and that shall be presumed to have been exposed during such service to a herbicide agent. So this is what they commonly refer to as boots on the ground, that we can show through your military record or through a stay in a military hospital in country that that in essence you had boots on the ground. Over the years, they've had several issues that have occurred to contest that in the courts. One of them happened to be, and I think it's the next slide here, Blue Water Navy. If you could go to that one, there you go. So this was an issue that was contested in courts for many years by Navy veterans, and it was recently won, and it's now Public Law 11623. What it refers to is that Navy veterans who were on board ships within 12 miles of the coast of Vietnam are considered to have served in Vietnam. So in other words, it's no longer an issue of boots on the ground, it's proximity to Vietnam. And this was a case that had gone on for many years in court, and it was finally won by Navy veterans. And as you can see there, it says it expands the presumption of exposure to Agent Orange to veterans who served on vessels operating not more than 12 nautical miles seaward from the demarcation line of the waters of Vietnam and Cambodia, right? Well, here's where the issue comes into play. There are two variables as far as the Navy is concerned. One is referred to as brown water Navy, which are the inland waters, and the second is blue water Navy, which is the ocean waters, the Gulf of Tonkin, 12 miles off the coast of Vietnam and Cambodia. And so one of the things that we do is we have to go through an investigatory process to determine whether or not the ship that Navy veteran was on was actually within those 12 miles. So we spend a good deal of time trying to make sure that we know exactly where that veteran was and exactly where their ship was before we make the determination. All right, our next slide. So the C-123 aircraft is actually the Air Force's and the Air Force Reserve's aircraft that distributed Agent Orange. And for many years, veterans had fought to be considered as being exposed to herbicide. And recently they approved this, that the individuals who were on board that aircraft, assigned to those aircrafts, maintained those aircrafts as well, should be considered to have been exposed to herbicides. So that just happened recently as well. Next slide. They also considered that there are certain places in Thailand where Royal Thai Air Force bases that were in Thailand, where many of our aircraft were stationed and maintained, had flown out of. And you can see that there's a list of 7 different bases that they know that herbicides were sprayed around in the area of that base. And if an individual was in close proximity to that, then they would also be considered to being exposed to some type of herbicide or to Agent Orange. But it does not include everyone that was stationed at that base. So if we go to the next slide, it'll clarify a little bit better who those individuals are. And these are individuals that they know were patrolling the perimeter of that particular base in Thailand. Obviously, security policemen, the dog handlers, members of security police squadron. But then it gets a little more complicated when you're dealing with individuals who may have been assigned to as a or detailed to a security police squadron that were assigned out to the perimeter of the base to patrol the perimeter of the base. So again, we go through a very healthy investigation of trying to make sure that we have the right individual and that we can put them at that base so that we can um, address the issue of their exposure to herbicides. Next slide. Also, we concede herbicide exposure on a direct or facts found basis for Army veterans who served on Royal Thai Air Force bases in Thailand if they provide statements that they were involved in perimeter security duty and there's additional credible evidence supporting this statement. So again, we're trying to make this as inclusive as possible to address all the variables that had taken place during that war. Our next slide. So now we get to an issue called Nemer. And Nemer, the gentleman, the name of the gentleman, obviously, his last name was Nemer, and he fought for many, many years in the courts to have certain medical conditions addressed by the VA as presumptive conditions related to exposure to herbicides. And eventually he won that case. Some of those conditions were ischemic heart disease. Well, that's probably the biggest one, was ischemic heart disease. Veterans that experienced heart conditions after having served in Vietnam. And when he won that case, what had happened was the courts came back and they said, okay, any veteran who had ever claimed any one of these conditions should the VA should go back and reevaluate that claim so that they can be compensated for that. And if the veteran is no longer alive, then that compensation should go to the next of kin. So what happens is, so that took place several years ago. Don't quote me on this, 10 or 11 years ago was the initial time, but as new presumptive conditions come up and as new court cases are resolved and laws are passed, like for instance, the Blue Water Navy, it now brings back the issue of Nemer, where the VA needs to go back, take a look at all the claims that were filed by Vietnam veterans who are now considered exposed to herbicides and readdress the presumptive conditions and the new presumptive conditions that are related to that. Now, Nemer only applies to people who had filed for that condition way back when. If they've never filed for that condition and been denied, then it does not fall into the Nemer category. And this is such a large undertaking by the VA that the VA has come out and they've said, okay, we're going to designate certain regional offices to handle certain types of certain portions of Nemer cases, whether it's Blue Water Navy or veterans who are still alive or the surviving spouse or children or parents of the deceased veteran. So that's a very I'm trying to make it as simple as possible. I realize it sounds very complicated probably, but it's the VA's effort to make sure that we address every single veteran that falls into every single category. And by having regional offices designated to handle specific portions of Nemer cases or Blue Water Navy cases or such, it allows a more focused and a more comprehensive assessment of each one of those cases. Our next slide. I also mentioned that in Korea, they have evidence that Agent Orange was sprayed near the demilitarized zone. That happened between 1968 and 1971. Again, it's one of those types of claims that we do a great deal of investigation to determine that the veteran was operating or near the Korean demilitarized zone where those herbicides were sprayed. So again, it's a matter of proof, and it's an extensive investigation to ensure that we have all the individuals that are who were there covered by the VA and compensated appropriately. Next slide. Well, now we get to the Gulf War presumptive cases, and this just happened recently. These are the approved presumptive conditions that are related to Gulf War. And so the issue with the Gulf War is that there is ample evidence showing that burn pits were used or that they were being that they were pretty much going on at every single base. And it wasn't just a matter of we're burning extra cardboard for the new thing that we got. It's also there's evidence of burning batteries, burning chemicals, burning just all kinds of ingredients, and obviously those that smoke and the byproduct from those burns wound up in the air, and the result of that was that veterans were completely exposed to that. And so what the Secretary of the VA said was, all right, let's start with the asthma, the rhinitis, and the sinusitis, including the rhinosinusitis conditions that veterans may have experienced. Now, previous to this, they, excuse me, they referred to it as a undiagnosed illness due to Gulf War, and now they're beginning to identify specifically what the conditions were and what the results of those, what the medical diagnoses are from those conditions. But this is going to go further. And now currently we're dealing with this. The VA is dealing with this and addressing this and capturing this information. But if we go to the next slide, you'll see that, let's see here, you'll see that these are proposed presumptive conditions that the Secretary of the VA is addressing. You'll see the highlighted section there, which is the Secretary is initiating rulemaking related to presumptive service connection for the following 9 rare respiratory cancers for certain veterans. And if you remember in the President's State of the Union address, he began to address some of those things, some of those conditions that we needed to take a good, long, hard look at. So this is in the pipeline in terms of new presumptive conditions that we believe will be included in the Gulf War presumptives. If we go to the next slide. So these are some of the contact numbers that you can reach out to the VA through a wide variety. If you would like to come into our office and schedule an appointment, you can do that through that second line where it says Phoenix Regional Office, www.benefits.va.gov/Phoenix / and there's a icon at the bottom of that page called VERA, Visitor Engagement Reporting Application. You can schedule an appointment, pick the time that you want to come in, pick the day that you want to come in. If you just like to get a phone call from us to talk about the issue instead of driving all the way down here, we can do that too. We're also working on trying to establish a video link with veterans so that in the future, we might be able to just call them on their phone and talk to them for a few minutes about what it is they have concerns about. But as you go further into this, you'll see that there are other avenues that you can that you can pursue and that you can talk to individuals. We had a long conference yesterday with the Arizona Department of Veterans Services. And they were very helpful in terms of letting everybody know, here's how you get a hold of us, here's what you do, here's what we need, so that we can get going on the right track. And you see down there at the very bottom, check out the ADVS As Vet Virtual Education Series playlist on YouTube channel. So there's you can gather some information right off the bat about what to do, or maybe what to ask, or what information you need to collect before you come in and talk to us. Our next slide. So before we get to the questions, I want to address one other thing. There is a bill in Congress at the present time that's dealing specifically with Gulf War veterans. And Gulf War veterans would include veterans, believe, between 1990 and present day, who were somewhere in the Gulf, boots on the ground, and that we consider to have been exposed to the byproducts of burn pits, what they call particulate matter in many cases. And the bill is called Honoring the Pact. It's making its way through Congress. I'm not trying to promote the bill or not promote the bill, just to let you know that on that bill, there are approximately another 14 or 15 other presumptive conditions that that Congress is asking the VA to consider as well, as part of the presumptive compilation of illnesses that veterans experience from being exposed to particulate matter and burn pits in the Gulf War. So before we get to Mike, are there any questions that we can answer? And then I'm going to give Mike like the last 10 minutes, unless you want to, Mike, unless you want to go now, and then we'll move on to the next part of questions.
I did see a question, John, about Guam.
Okay.
And then what does presumptive mean when you're making a claim?
All right. Let's see what we got here. So currently right now, there are not presumptive conditions that are related to being stationed in Guam. However, there are always, I guess the thing to say about this, and hopefully if you saw on the slide about the new conditions that the secretary is addressing, and coming up with a game plan. Oh, that one right there. Right there, right at the very beginning, what you see is that they're basing this upon studies and reports that have come out of the National Academy of Sciences, Engineering, and Medicine. In this particular case, for presumptives of Gulf War, they wrote a report entitled Respiratory Health Effects of Airborne Hazards Exposures in Southwest Asia Theater of Military Operations. So it's, again, it's a very extensive, laborious process to try and make sure that we have all of that information. There are a wide variety of things that have happened around the world that our military veterans have been exposed to over the years. And the result of that is that the secretary orders these ongoing investigations to make sure that we're covering all those veterans and potential presumptive conditions that could result from their exposure to different things in different locales throughout the world. All right. Let's see. Marky Mark is asking, what does presumptive condition mean to someone making a claim? Well, good question. All of the national service organizations and all of our employees at the VA are consistently trained on what to look for as far as presumptive conditions are concerned. So I'll give you an example. I had a veteran that came in the other day. The veteran served in Vietnam, and they are service connected for several different conditions that are presumptive conditions. So he's considered to be boots on the ground, and he's made application and gotten gotten compensated for several different illnesses and diseases that he has. But he came in, and the question that he asked was, hey, I heard that there are new presumptive conditions for respiratory conditions. And after a brief talk, I explained to him that those new presumptive conditions are related to Gulf War service and not Vietnam service. So the presumptive condition is what the VA designates as a medical condition directly related to service performed in a particular area or a condition that may have occurred. So, for instance, if the veteran was a prisoner of war, there are only certain types of presumptive conditions that that individual would be compensated for related to that type of event in their life. If we move further down, let's see. What does a burn pit grant a veteran when it comes to VA claims? I was deployed to the Gulf recently and was told to fill out a form. I did, but does this entitle me to anything, or is it just for the record? So this is from Sebastian. Again, another great question. So unfortunately, there are a lot of different things that that happen over the course of time for many, many years. There have been the VA hospital has offered to get a veteran onto a different registry or different types of registries. So a Agent Orange exposure registry or a Gulf War registry or things along those lines. And so if that's one of the forms that you might be talking about in that terms, that does not instigate or initiate a claim. In order to get that claim started for presumptive conditions, you would have to come to the regional office and sit down with one of our counselors and go through the record and go through the discussion of what types of conditions or what types of illnesses that you're currently going through or that a veteran is currently going through. And the biggest issue that I can let you know on this whole thing is if you don't have medical documentation of that illness existing, you should try to get some. That's as simple and blunt as I can make it. That's probably the most critical thing. If we don't have medical proof that something has happened, it's very difficult for us to move on from there. How does the use of tent heaters without adequate ventilation and burning waste pits figure into the condition? Laura, again, good question. The issue is for Gulf War presumptive conditions is that if you were in the Gulf, you're considered to be exposed to burn pits, whether you were in close proximity or far away proximity. As far as tent heaters are concerned, that is not one of the issues that they consider to have been a contributing factor to an illness. But if you do have that illness and we're in the Gulf, then the presumption is those burn pits did have some type of an impact. Again, marking Mark, I'm a Desert Storm veteran, referring to those presumptives mentioned. And Sebastian has the same concern. Laura, is a Desert Storm veteran, also in theater, got sick with significant respiratory illness and breathing difficulty. And then after I got home, I was diagnosed with asthma. Again, that's a perfect example, Laura. If we can show that you were in the Gulf, in Desert Storm, and now you have difficulty breathing and diagnosis of asthma, that is a presumptive condition related to Gulf War duty and exposure to burn pits. Let's see, Leslie put in something. Yep, regional office is the best way to go. World War II, landed Iwo Jima 5 days after invasion. Army engineer has his job to purify water on Iwo Jima. He was there 11 months and past 15 years, developed tremors similar to Parkinson's. 98. Does he have some type of chemical reaction to purifying water? The chemicals alone on Iwo, constant shelling, 45 days, 11 months on the island. The best thing I can tell you is, Kathy, let's get you in here for an appointment. And if you would share that, share your contact information with Leslie, and she will get it to us. I got more and more questions here. Illnesses have to be documented prior to making a claim. Not necessarily, Mark. The claim goes much faster if we have a diagnosis of a condition. That's what the critical element is. If you don't have the diagnosis of the condition and you claim the condition, doesn't necessarily mean that, well, let me put it this way. Excuse me. If you do not have a diagnosis of a condition after serving in the Gulf, then when you make application or when you make a claim for that condition, and it's determined that there is no evidence to support a medical condition, a presumptive medical condition for Gulf War duty, then that claim would be denied, right? So the best example that I can give you is I had an uncle who was exposed to radiation. He had all the proof of being exposed to radiation, but he didn't have any of the conditions or medical diagnoses that were related to his exposure to radiation. So when he had asked me, you know, what should I do about this? I said, if you don't have the condition, then there isn't any compensation related to that. So, but again, it's always beneficial to you, the veteran, to get to a doctor, get a full checkup, go through that whole process of finding out whether or not you do or don't have any of those conditions, because as you can see, the list of presumptives is beginning to grow. Yes, Leslie's got it right. Presumptive means if you were stationed there, they presume that you could have been exposed. And it's not even a could, it's if you were there, boots on the ground, you were exposed. Doesn't matter how close you were, how far away you were. Let's see, is that it? Okay, Mike, I think it's your turn. I think I gave you 5 minutes. Thank you for your time, folks.
Here we go. Where we go. There we go. So, well, thanks a lot there, John. My name is Michael Watson. I'm with the Department of Veteran Affairs here in Phoenix, and I'm an outreach specialist. So today I'm just going to touch real briefly on basically some common claims that we actually see here in public contact here in Phoenix, and some of the things that you probably want to keep in mind, or some of the things that you're probably not doing that you should actually be doing to help further your claim. So some of the things I'm going to talk about is the common benefit, and that common benefit will be the compensation. So basically that compensation will go along with something that you occurred an injury let it be physical or mental, that was actually in service, and something that was documented in your service treatment records, which what we would call like STRs, and that you'll probably bring forth to file a claim. Now, I'm just going to throw out an example. Let's say that you got out in 1990, and here it is 2022, and you had a back condition in the military. Well, some of the things that you're probably going to want to show is what you would call as continuity. Basically, that continuity of that disability is when was the last time you got treated for that disability or that injury that you had in service versus out of service, because of, you know, you're talking about 25, 30 years. And to have those documents where you were being seen, going to chiropractors, seeing outside doctors, seeing doctors that's at the VA, those there be really helpful when you're trying to file a claim, especially if it's your very first claim that you're filing for that condition. Some other things that you probably want to consider doing is getting what we would call like a nexus letter. Some of those nexus letters that you can have done by your primary care doctor, probably know them as a PCP, and basically be able to relate your condition, your disability that you have currently to something that would happen in the past. So a prime example of that, always kind of go through the back, is because if you was to get an x-ray on it and you had damaged it once before, the x-ray sometimes can tell if there was some former damage that was actually done to that back. So having those good medical records, getting a nexus letter is something that you can bring forward to have a successful claim with the Department of Veteran Affairs. Now, from my understanding, Bill yesterday, one of our service officers, had some very good slides. Looks like they will be available to you guys within the next 2 to 3 days here online, where you go back and review some of those if you didn't get a chance to pop online yesterday. One of the other quick things that I was going to talk about is basically when a veteran have challenges with their discharge. We kind of spoke on that yesterday, so you'll probably be able to review that as well. But I will go ahead and hit one of those forms that is very commonly misused, that a person don't seem to send in to their prospective military branch, and that'll be the DD 293 form. Now with that form, you know, like I spoke on yesterday, what you want to have accompanied with that is some character references. And what I mean by those character references, it could be a priest, it could be a neighbor, it could be a mother, your father, your sister, your brother, you know, your next door neighbor, someone, or your manager who you're currently working with right now, something that you have actually been doing since service to basically make you a pillar of the community now, something to get that discharge overturned. Because if you get it overturned, we can actually look at those and see if we be able to grant any type of benefits that you had injuries for while in service. And sometimes a lot of veterans, they get their discharge kind of confused, where you can have 2 periods of on your discharge. You could have served from 1985 to 1989, and then served from 1990 to 1995. And let's say the last period of your service was a dishonorable, you know, you got an OTH on it, unfortunately. But you had injuries in that first period. Well, the VA will look at that first period and can grant benefits on that first period. So just want to kind of go over a few of those things. And like I said, some of these slides and everything will be available here within the next 2 to 3 days. So I'd just like to thank you guys for your time. Thank you for popping on, and hope you guys learned a lot. But like I said, we're always available for any in-person questions here at the Department of Veteran Affairs. Down